Hello, YouTube. I'm Vince White. I'm an employment attorney. On this channel, we answer publicly posted questions from YouTube users, getting folks the answers they need from an employment attorney. We have a question from YouTube user Carrie, and Carrie asks us, I have a question for you. Why do you think that some attorneys, I think employment attorneys specifically, won't take cases from employees who have not worked a long time for their employer? Carrie, I'm going to supply you my own answer. However, I will say this. I reached out to 8 talented employment attorneys, 2 mediocre employment attorneys, and 1 paralegal in our field who's a bit of an asshole. Hey buddy. With this question, and I'll be upfront. A lot of people gave me answers but said, don't read this on your channel. Don't know why. I offered to let them be anonymous. They just said no. A couple of people told me to go, we'll call it go jump in a lake. And a couple of people gave me really amazing answers. So I'm going to supply the best of the best answers. I'm going to give 2 of them, and then I'm going to give my own thoughts. Let's open them up. All right. First answer. Well, actually, you know what? I'm going to give the negative answer first. So here's the prompt. I asked, why do you think attorneys don't want cases for employees who haven't been in a job for very long? And the response from anonymous attorney, who's very talented, he's a very, very grumpy fellow, but he's a very talented attorney. And he responded, longevity is relevant for valuation for virtually everything barring extreme discrimination or sexual harassment. Any performance issues are amplified for short-timers. So, I mean, that is essentially a perception argument, right? There is a perception that performance issues are amplified. Now, let's read what I view as the more positive answer. Same prompt. Hey, I'm taking a poll for a video I'm doing. I won't attribute you. Why do you think attorneys don't want cases for employees who haven't been at a job for too long? And this attorney said, go ahead and give me, go ahead and use my name. This is attorney Jesse Rose, who has a firm called the Rose Law Group. Full disclosure, Jesse Rose does trial work for my firm, and we were partners like 12 years ago in a law firm called the White Rose Group. It's been a long road, but he's a good guy and really good attorney. So he responded, I believe that the employer originally had a benefit of the doubt for new employees. But I think that benefit of the doubt has evolved into a same actor defense, which I will define for you, and terms in union agreements and employment handbooks that require that employees pass certain initial quality assessments during the probationary period. So I don't think that the duration of employment is as important anymore if you address those issues in analyzing the case. And I do fully agree with that, but I will note that that might have been a very complex response. So really quickly, let me hit you up with the same actor defense so you understand the concept that he referenced there. I'm going to read a definition. The same actor defense is a legal theory that employment lawyers use to argue against discrimination claims. It's based on the idea that if the same person hires and fires an employee, the same actor, the same person who hires and fires, within a short period of time, it's difficult to believe that the termination was based on illegal discrimination. This defense can be used in cases involving discrimination based on race, gender, ethnicity, or age, and really any protected class. Okay. So, functionally, my answer is the same. I do believe the same actor defense must be dealt with. And often it is a hurdle and many employment attorneys may view that as a lot of additional risk and not want the case. But if you can explain why the employer should not have the benefit of the same actor defense, not be able to argue, well, how can they be, I don't know, racist or ageist or religious, engaging in religious discrimination, whatever it is. They knew about the protected class when they hired. So why would they have hired if they were prejudiced against a protected class, right? It's unlikely to be discrimination if they knew about the protected class when they hired. So there's a lot of things you can do to defeat that, and I'm not going to name them all, but the simplest one is just say, hey, they didn't know. Or even you can make the argument, okay, they did know, but they had a motivation, like they were shorthanded and they needed someone, so they hired the person, even though they were prejudiced against the person. And then once they no longer had the extreme need, the extreme short staffing situation, they let the person go because they are prejudiced against that person's protected class, right? So I agree largely with the second attorney, Jesse Rose, there. Now, that first attorney, that is the more prevalent school of thought. And he's not wrong. Like, if you don't deal with everything, a lot of extra work, a lot of extra risk, and that can be difficult and less appealing to deal with for an employment attorney. I will say that my firm does not feel that way. I do not feel that way. I know many attorneys who view that on a case-by-case basis and do not blanket feel that way. And even this attorney, Mr. Grumpy Pants, feels that it is case-by-case. Because you noted in his question, and I'll read it. What did he say? What's the exact phrasing? Everything barring extreme discrimination or sexual harassment. So things are really bad, then he doesn't mind it anymore. He doesn't mind a short duration of employment anymore, right? So what he's telling you is even he, who feels that this is a great reason not to take a case, even he is doing a case-by-case analysis. Firms that fail to do a case-by-case analysis in this situation, very foolish in my mind. Like you're walking away from helping people who could make you a lot of money. So, long story short, it's not something you should view as a bar to obtaining an employment attorney. That is not what is going on. That is not what you should believe. You should not believe that you are bereft of representation. I'm going to sneeze. Excuse me. Hay fever this year. My God. So, Carrie, do not think a short employment duration is an open and shut no. Even the grumpiest attorney responded to me. The tightest of the tighties, the sharpest of the sharpies, the grumpiest of the grumpies, would still give you a case-by-case analysis. He wouldn't even let me use his name. He would not even let me use his name. But he would still, being very talented, making people millions, plural, per year. He's not even a partner in a firm. He's just an associate, and that's how good he is. He would still give you a case-by-case analysis. That's important. Now, myself, Jesse Rose, we're very more open. We tend to view that as something that can be dealt with if we can see the path to deal with it or imagine ways that we could creatively deal with it, which is tremendous, right? Everybody wants to deal with it. Nobody wants to leave someone unhelped because of this issue. Listen, if I don't think I can make a case into money, I won't take it. It's that simple. I can't afford to. Right? Like I can't afford to pour tons of money covering expenses in a case, tons of attorney time into a case, and then think it's not going to recover. That amounts to me throwing away that money. I will never get it back. Ever. So when I say I'm more open, I'm not like, I'm just taking cases. I'm like, no, I sincerely believe this is something that can be dealt with if done proactively, with specificity, with creativity, with intentionality from the start. Like when you take the case, you can't just be like, figure something out. Like, figure something out, maybe 3 somethings, because maybe one of them is not going to pan out. Figure some arguments out, some really strong evidentiary arguments you can make out in advance before you take the case, because if you don't, if you just say, figure it out, money, you're just yeeting it out the door. Can't be. But, again, Carrie, I believe those cases can and should be represented, and I believe attorneys should take those cases. And if you're finding attorneys who won't take that case, it is not universally true. There are certainly attorneys out there who will take that case if they think it has merit. And also, listen, there's also attorneys who will take that case if they don't think it has merit because they think they're going to get a nuisance settlement of like 10, 15, 20 grand, or they're charging big money up front and they'll take it because they're going to profit that way, right? There's firms that take 15, 20, 30 grand, whatever it is, on just an agency case, not even a federal litigation or something like that up front. And those firms have no intention, of like putting up big numbers in that case. Or there's firms that take cases hourly who have no intention, right? I don't think there's anything wrong with the firm charging up front, but I think you need to, and trust me, like, I don't think there's anything wrong with the firm charging up front. But you need to believe that firm in your heart of hearts is looking to spend heavily on this case, put a lot of hours into the case, and really try to turn it into a win so they can make actual money, right? That's what you have to believe if you're paying an attorney up front. Anyways, I love this poll style question, and I'm really excited the channel's large enough that attorneys will actually answer my questions now. I will say the paralegal said some rude things to me. So, although we're good friends, apparently the channel's not big enough for the paralegal to answer yet. If this was helpful, comment down below. Tell us what you think. Tell us your thoughts on the same act of defense. Tell us your thoughts on whether duration of employment should be meaningful for the valuation, meaningful for the process of an attorney deciding to help a case or not help a case, represent a case or not represent a case. I would love to hear your thoughts. But also, if it was helpful, like, subscribe, comment down below. Share the channel so it can grow. I hope you had a lovely weekend. It's Monday now. I'm heading to New York this evening. And, it's not Monday now. When you see this, it will be Monday. It's late Friday evening right now. But Monday evening, I will be heading to New York to the new super sick, super sweet office. And hopefully I'll be shooting videos from there while I do other work. I'm not going to shoot videos, frankly. That would not be a good use of my time. But I'm going to be there anyways, doing some other stuff, and I'm going to shoot some videos, and I'm super pumped about it. I can't wait for you to see the new office. Take care, everybody.